Hi, everyone. Can you hear me? If you could hear me, could you type in the chat? Just give me a sign. I want to make sure my earphone works. Thank you. We are going to start our live stream webinar on the impact of this big layoff wave to the working visa and the green card. So we will start in about 1 minute. Okay, I think our starting time. Thank you, everyone, for joining our live stream. And first of all, let me introduce myself. My name is Feng. I'm a business immigration lawyer. I have practiced business immigration in the United States for about 15 years. So I have this channel and also another English channel to share my expertise, my tips. From the channel, you will be able to see we share a lot of inside information and our expertise on different kind of topics. They all related to business immigration, including working visa and green card applications. So today, we are going to cover um, the issue related to the big layoff wave. So when there's a big layoff, it will impact foreign workers, especially when they are holding working visa and they have green card application ongoing. So what's the impact for the layoff to their working visa and the green card application? Many have asked the questions. So today, our seminar is going to cover all of them. And the seminar will be the 30 minutes. The first 30 minutes is my presentation, cover those topics, and followed by FAQ. So if you have any questions related to the topics, you can ask your question in the chat. And after my presentation, I'm going to cover your question. So today's presentation and the whole live stream is about 1 hour. I share a lot of videos, but I don't do the live stream or seminar that much right now. It's because it's very busy season for immigration for the reason that everybody knows. So right now, what's going on right now is we see a big layoff wave going on in the United States. So last week, Meta cut out more than 11,000 employees. That's about 13% of its workforce. And we see Twitter laid off 3,700 employees. And Amazon is going to have a big layoff in the next few weeks. And also, besides high tech, we also see retail big layoff like Walmart. So what's going on right now? There are a lot of foreign workers who work for those big companies, and what are the impacts to their working permission? So before we explain exactly how to maintain your legal status, how to minimize the impact of your green card application, we need to explain a few concepts that are often misunderstood by a lot of foreigners. Because of the misunderstanding, people make innocent mistakes, ruin their status without even knowing it. So I think it's very important for us to cover that before. Um, for each foreigner, if you are in the United States with a legal status, you can only have one legal status at a time. You could have multiple visa in your passport, like you could have a valid B visa, F visa, or H-1B visa, but depends on your latest entry to the United States or your latest approved petition in the United States. You can only have one status at a time. If you want to transfer from status A to status B in the United States, at the moment of your transfer, which is at the day USS receive your transfer petition, you have to be in legal status A. If at that time your status A already expired or terminated, you are not going to be successfully transferred from one status to another. So make sure when you do the transfer, you are in the legal status. When we talk about legal status, so what if I have not maintained a legal status? What's the consequence of that? So if you are not in the legal status for every single day, you are not in the legal status, you are accumulating unlawful presence. We talk about unlawful presence that has that's a serious violation of immigration law and it has very serious consequence. If you have more than 180 days unlawful presence, you are triggering a 3-year bar. What does that mean? It means you cannot enter US for 3 years, or your green card application cannot be approved for 3 years. If you are accumulating unlawful presence for more than a year, you will trigger 10-year bar, which means you cannot enter the US for 10 years and your green card application cannot be approved for 10 years. So unlawful presence has very serious consequence. We recommend our clients to try your best to stay in legal status every single day when you are in the United States. So these are the basic concepts we would like to cover before we dive in. What's the impact and how to maintain your legal status while you are holding a working visa and during the big layoff wave. So if you are legally working in the United States, you must have either a working visa or a working permit. So for working visa, there are multiple visas that will allow foreigners to work. E-visa, H-1B, LOTNP. So those are typical working visa will allow you to work. For working permit, EAD card is a very common working permit for foreigners to legally work in the United States. So those working visa, they have a valid period in your approval notice. So when you check your approval notice, they have a valid period for working visa, no matter what kind of working visa is. If you have a 3-year valid period of your working visa, that does not guarantee you are in legal status for the whole period. Why? Because your working status is related to your job. Once your job is terminated, you lose your legal status. So even you have a 3-year H-1B in your approval notice, if you got laid off during the 3-year period, you will lose your status in those 3-year period. So here we're going to talk about grace period, because if without grace period, the day you lose your job is the day you lose your legal status. So the 60-day grace period was enacted in 2017. So before 2017, for HO and L working visa, there is no grace period at all. Like I said, the day you lose your legal status is the day you lose your legal status. But right now, because we have a 60-day period, grace period, which means this 60-day grace period is very precious to help you to prevent a foreign worker lose their legal status because of the termination of their employment. So the 60-day grace period enhance the job portability and also help you to maintain your legal status. Then the next question is, what kind of working visa will have the 60-day grace period to help them to maintain status? E1, E2, E3, H1B, H1B1, L1, O1, and TN visa. So those types of visa, if you lose a job in the middle of the valid period, you will have 60 days grace period to help you to plan the next step, file application to maintain your legal status. The next question is, when does the 60-day grace period start? This is very important and a critical issue, because when does the 60-day legal grace period starts depends on how much time you have to plan your next step. Then this is the question related to the definition of the H-1B termination date. So when does your H-1B or L or O terminates? It's either the last day of work or the last day of pay. So there is many rumors online talking about this issue. So we're going to clarify that. When your job is terminated, you will get a notice from your employer. And your employer will also notify USCIS the termination of your job. So if your employer sends a notice to the USCIS on the termination of your job, that notice will have the last day of work. And that last day of work controls, which means your 60-day grace period will start the next day of your last day of work on the notice your employer sends to the USCIS. Meta offers 4 months pay package, plus additional 2 months of health insurance, which is very generous package. However, does that extend or prolong the starting of your 60-day grace period? Conservatively speaking, no. Because for that 4 months package, you are not on the regular payroll of Meta as an employee. This is the pay package for the layoff. So conservatively speaking, if Meta sent a notice to the USCIS, actually Meta doesn't need to, because everybody knows that. It is the public news. So if that's the case, very likely USCIS does not consider that 4 months you are employed. So this way, it's not like many things that, oh, I have 4 months and the 60 days will start after the 4 months, after the last day of pay. That's not the case. I would not advise my clients to take that stand, because conservatively, the 60-day grace period starts the next day of your last day of work. So that's how much time you get to plan your next step. Many small companies, like the layoff is not so public. It's not everybody knows when is the layoff and how is the layoff package. Small companies also don't notify USCIS about the layoff. If this is your situation, USCIS will use your last day of pay to determine the last day of your work. If that's your case, then your 60-day grace period will start the next day of your last day of pay. So it depends. It's different, depends on the situation, depends on how the layoff goes on, depends on how your employer notifies the USCIS about your last day of work. So that's how to define the termination date of your working visa. Then the 60-day will start the next day of it. We are continue talking about 60 days before we talk about the options you will have. So 60-day grace period, does that mean everybody will get the full 60-day period? Not exactly. So some people will get less than 60 days. Why and how? 60-day grace period will only be offered for those foreign visa foreigners who have a working visa, that whatever is left for your valid working visa period is more than 60 days. If whatever left in your working visa valid period is less than 60 days, whichever is less will be the time you have to plan your next step. For example, if your H-1B is going to run out in 30 days at the time you got laid off, you don't have 60 days to plan your next step. The step. You only have whatever left in your valid H-1B period. Only when the leftover period is more than 60 days, you will have 60 days left for you to plan the next step. So for the foreign worker, you have less than 60 days valid period in your approval notice, then you have whatever is left for you. Another possible situation is USCIS has the discretionary power to determine whether it could shorten your 60-day grace period. Why and how? When you have a violation of your status, when you have unauthorized employment during the grace period, when you have fraud or national security concerns, when you have criminal convictions or other violation or other reasons, USS could have a discretionary power to shorten your 60-day period. So on those kind of situations, please remember, not everybody has a full 60-day full-term grace period. So if you have less than 60 days left in your approval notice, you have that. If you have violation of your status, probably USS will shorten your 60-day period. And for some foreigners, they don't even have 60-day period. So how and why? Only one grace period for each petition valid period. What does that mean? Once you get your petition approved, during that approved valid period, you only has one grace period. Once you used out of this one, you cannot have a second one unless you have another petition approved. So this is one grace period per each petition valid period. So once you used out, you don't have a second one. And once the petition is denied, let's say you got laid off because the layoff caused the determination of your employment. But if you do H-1B transfer, if you do H-1B amendment, if that petition is denied by the USCIS, do you have 60-day period? No, you don't. So that's why in certain situation, you don't even have a 60-day period. So that's the 60-day period, how it plays in different kind of situation when you lose your job by laid off, or when your H-1B or working visa is denied for such a reason, or when you have a violation of status, how much time you get and what kind of solution you could take. So that's how the 60-day period is determined in the different kind of situation. So now we all know how much time left for you to plan your next step. Then what's the option for the next step? So for H-1B, L, O, or TN visa, if you got laid off, the next step, many will think, okay, I'm going to find another job. Once I get another job, I can do H-1B or L or O, TN transfer. That's the best. If you could land a job in the next 30 days, remember, suppose you have 60-day full term. I would say you only give yourself 30 days to land another job. Confirm, go interview, confirm with employer about the job, and confirm with the sponsorship of the working visa. And then you need time to prepare your petition because your transfer petition has to be submitted to USS before the 60-day grace period runs out. So a lot of people think I have 2 months to find a job. That's not practical because lawyer needs the time to prepare your working visa transfer. And for H-1B, for example, it takes from at least 10 business days to get it ready because LCA itself takes 7 business days for Department of Labor to certify. So that's why you need to have leave enough time for a lawyer to prepare for your case. So you probably only have 30 days to land another job and get every paperwork ready to file it before the 60-day period runs out. If you could not land a job within the first 30 days, think about the plan B. Your plan B could be if your spouse has independent status, let's say your spouse is F1, you could transfer to F2, transfer to dependent status. If your spouse has H1B, you could consider H4. If your spouse is J1, you could consider transfer to J2. So dependent status helps a lot. And if the first two options are not practical for you, then you probably need to think about bridge to temporary status, such as F and B. So for F status, you have to find a community college or local program that's very flexible on the enrollment date, can give you I-20 as soon as possible. You could bridge to F status to win some time to find another job and to do H-1B transfer. Or you could transfer temporarily to B1 or B2 visa and give yourself more time to stay in the United States and look for another job. However, for transferring to B or F as a bridge to temporarily stay in the United States may not be the ideal practice for you because USS takes a very long time to adjudicating those two kinds of cases. And that will complicate the situation if you land a job later and you want to transfer back to the working visa. Because whether your transfer of employer could be approved depends on the breach status result. And if that takes USS a long time to do B or F, your change of employer working visa petition will be delayed as well. So we have done quite a few this kind of cases, and USS has been very slow and giving petitioner and beneficiary a very difficult time to sort out. You have two petitions pending at the same time. So that's a situation I would suggest if that's the only options you have, talk to your lawyer, try to figure out if that's the best solution for you and plan the timing. The timing is very, very critical. And be careful with the two petitions pending at the same time because that will complicate it with each other. So that's the part how to maintain your status, how to calculate how much time you have, and what kind of options do you have. If in those 60 days period, you could not find a job and you don't have a spouse to use dependent status, or you don't want to transfer to F or B, then the next option for you is to leave the US before the 60-day grace period runs out. And you could continue look for a job outside of US. And once the H-1B or working visa is approved, you can come back. So keep a valid status at all time. That's our suggestion because the unlawful presence, the consequence is unbearable. So that's how you maintain your legal status while a layoff is ongoing. So that's the maintain of status part. Next, I'm going to cover how to minimize the layoff's impact to your green card application. No matter you have approved I-140 or pending I-140 or even pending labor certificate perm petition. So the layoff will have a very big impact on them. First of all, we're going to talk the best situation. If you already have approved I-140 and if your I-45 already pending for more than 180 days, your layoff or change of your job will have very minimal impact to this green card application. You just need to be very careful. If your next job is very similar to your green card job, your I-140 and I-35 will not be impacted. And you can keep those petitions pending and you will be granted the green card as long as your next job is very similar to the green card job. However, if you have not filed I-45 yet, but you have approved I-140, and that I-140 was sponsored by the employer that you are laid off. So if that's the case, you have two kind of situation may apply to you. We know the green card application is not for the current job, it's actually for future job, which means your current laid off may not impact the future job offer. If your employer believes it can keep the job offer open for you, it welcome you come back to work for it once you get the green card, and the perm job offer will be open to you. Then this I-140 could be could could be fine, even you are laid off right now. So as long as your employer wants to keep the job offer open for you in the future, your I-140 will not be impacted. It will still be valid. And once the visa number is available for you, you can file I-35. You can go ahead to do the rest of the green card application. However, the majority of the case would be once you got laid off of your current job, probably the laid off will eliminate your future job offer as well. If that's the case, your I-140 could be revoked by your employer. If your employer doesn't do any action for the I-140, this approved I-140 could offer you a very important benefit, which is the priority date of your I-140 could be carried over. So the priority date is very important for China-born and Indian-born alien, because we know the visa number is not sufficient for everybody who are waiting in line for the green card from those two countries. So that's why for Indian-born and China-born alien, the waiting for the green card is pretty long. The priority date is the date to calculate how much time you can wait for the visa number. So if you have already have approved I-140, and if your employer does not revoke this I-140, this I-140 could offer you an earlier priority date, which you could carry over to your future green card application. And that will make your life much easier by keep your queue in the line. So that's the benefit you could get. What if when the layoff is happening and your I-140 is still pending? So in this kind of situation, of course, we have two kind of scenarios. If your employer keeps your future job offer open, your pending I-140 can continue, and once it's proved, you can carry over the PD date, or you can file I-35 without any problem. But if the layoff eliminates your future job offer and your employer can withdraw this I-140, then there is no benefit for you to take away. Once you find the next employer, if the next employer will sponsor your green card application, you have to wait in line again. So that's the situation. It's very unfortunate, but this is what happened if your I-140 is still pending or your labor certificate is still pending. So that's the impact for the layoff to your pending or approved green card application. So in the green card session, you will notice if your green card is sponsored by your employer, you're pretty much tied up with this employer, and it will be impact if you lose the job and if the employer does not have the future job offer for you anymore. So that's a very frustrated situation. No matter what happened, I always suggest my clients to have a plan B, because plan B will offer you more options and will make your situation more stable. If you could have a self-petitioned green card application, what does that mean? That means if your green card application does not need any US employer sponsorship, for example, EB-1A or NIW, then your green card will not be impacted by any layoff, by your change of your job, it will be there valid for you forever. So that's why I would suggest you talk to your lawyer to evaluate if your credentials meet any self-petitioned requirements, and you could have a self-petitioned green card ready on the side that will not conflict with employer-sponsored green card application, but will offer you extra option and cushion. So whenever any laid off or termination of your employment happened, your green card application will not be impacted. So that's a self-petition suggestion. So either EB1A or NIW petition could be self-petition because those two types don't need employers' sponsorship, and doesn't matter when you change your job and how you change your job, you will be safe. So I believe I kept my 30 minutes presentation very on time. So that's the major issue I would like to cover when for the working visa holders and in a big layoff wave. And if you have any questions, you could send to the chat. I would like to answer your question. And um, this session is offered for free. So if you have any questions, I'm here to answer them. And hopefully today's information could help you guys to sort out a frustrated situation and sort out how to maintain your legal status and sort out the future plan, whether you should have a plan B and whether your working visa could be well maintained. Of course, I understand that many of you have already starting looking for next job. I would always suggest my clients always be well prepared, always have a sense of insecurity, no matter how well this job paid, always keep yourself up to the market. Look for the next job, look for the next possible employers, and do your network, know more person in the industry. So this way, whenever there is anything happened, you could have a potential employer that's already know you, have talked to you, and know your expertise. Maybe you will be easier to land the next job than others. So I think that's pretty much the points I would like to cover in my presentation. And I will give you guys a few minutes. If you have any questions, you're welcome to raise your questions here, like the details of how to do H-1B transfer, the timeline. We covered a few of that. But when you talk to the lawyer to do your next H-1B transfer, make sure you know the lawyer's working schedule, the lawyer's promise of how and when they could help you to prepare submit your H-1B transfer petition, because everything matters and timing is very critical here. And another suggestion I often give to my clients is don't eye in a big company. At the big layoff happened, big companies they tend to take longer to do the onboarding processing. So that's also a very precious time for you. If you go to talk to smaller companies, they are more flexible and the onboarding processing is much simple. And also they offer you a lot of flexibility to submit H-1B petition transfer as soon as possible. So just talk to different employer to see who could meet the requirement of you being maintaining your status. I think that's all I could cover today. And if you don't have any questions, I guess I will just end my live stream. Um, you can subscribe to the channel. I don't do that much live stream, but I will try if there is any demand. But we will constantly posting my video regarding different kind of issues that my clients or potential clients possibly they are interested. So give us subscription and then give us a thumbs up, or you could leave in the comments like the questions you would like me to cover in the next session. We would be happy to. Okay, I guess nobody has questions, which means I answer all the questions. Thank you very much for joining our live stream. The recording will be uploaded in the channel as well. And thank you very much. If you think our information is helpful, you can share our information to your friends who may need our help. Thank you.